Now I'm going to hit the start button. Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am Executive Director and Vice President of WLF's Legal Studies Division. For 47 years now, WLF has been one of the premier public interest law and policy centers in Washington, with a national focus on trying to advance our mission, which is to create a legal and regulatory framework that is at least amenable to free enterprise, if not sympathetic to it. Also protection of individual and business civil liberties, and a general advancement of the rule of law. The webinar is one of the programs that we put on here at WLF to educate the public on a wide range of issues. One of our main functions is filing of amicus briefs and regulatory comments to our litigation division, as well as our legal studies division, publications, and blogging as well. If you have some time afterwards, please stick around and check out our website, which is wlf.org. Pleased to have our speakers with us today to discuss a topic that is one that WLF has done, I think, at least 2 other webinars on and published quite frequently on. That is PFAS-related litigation and regulatory issues. PFAS are a group of 3,000 to 10,000 synthetic fluorine-containing chemical compounds that have proved highly useful in a large number of consumer and industrial products. They were invented around the 1940s. They have inherent water, grease, heat, and in degradation and resistant properties. So that's why they're very popular for a number of uses. As you'll see from one of the headings of our panelist slides, PFAS are ubiquitous. Even though the debate rages on over the level at which substances like PFAS are toxic to humans, federal and state legislators and regulators are moving forward with any number of actions ranging from explicit use limits to broad disclosure regimes. All of those actions and all of the discussion of PFAS, of course, so here and internationally, propel private litigation over how manufacturers use PFAS and over what they say and don't say about their use. Our panelists have a lot of ground to cover here today, so let's move forward. I want to note that we're recording this session. If you have a question for our presenter, please use the Q&A function located in the Zoom webinar toolbar. And introduce our speakers. Joel Eagle is a partner in Thompson Hine's environmental practice. He represents public and private entities in the industrial, commercial, and manufacturing sectors, where he focuses his practice on all aspects of environmental law, including regulatory development, site remediation, and risk management counseling for emerging contaminants, including, of course, PFAS. James Fraser is a senior counsel with Thompson Hine here in DC. He's a former associate chief counsel for litigation at the U.S. Food and Drug Administration. His product liability practice focuses on FDA-related regulatory matters, litigation, and transactions. He advises and represents FDA-regulated companies on issues relating to product approvals, labeling, and current good manufacturing practice requirements. Last but not least, William Hubbard is a partner in Thompson Hine's product liability and construction practices here in DC, represents businesses and property owners in mass tort and class action issues involving building and other consumer products, as well as litigation involving alleged exposure to chemicals or environmental contamination. So our speakers are going to be using a slide deck that is available to you to download if you like as a PDF in the chat. And there's also a link to a paper that Joel authored for WLF last year in the chat as well. Joel, I'll hand it over to you.
Thank you, Glenn. I'm going to share my screen. Glenn, just give me a thumbs up if you see it. All right. All right, well, we do have a lot of ground to cover, and each one of these topics could be its own presentation, frankly, and we have about 20 to 30 hours of material in here, so I'm going to get right to it. And a lot of the slides we'll go through relatively quickly, but as Glenn said, you will have access to them, and that's intentional in order for you to have more information than we could cover in a short period of time. So the topic of our presentation, or the title, is PFAS Legal Risks 2024, Will Disclosure Mandates and New Rules Widen the Litigation Landscape? The answer is a profound yes, most likely, and we're going to get to that throughout the slides today. So this is a roadmap of what we're going to cover today. Keep your seatbelts, PFAS, there's a lot to cover. PFAS has been in the news and has been in the regulatory and litigation space for many years now, and 2024 is certainly going to be another very busy year. A couple of takeaways that I think are really important. what is PFAS, or more accurately, what are PFAS? Because PFAS are a category, as Glenn mentioned, of a group of chemicals, 3,000, 8,000, 10,000, 15,000, several million. It depends on who you ask, but PFAS are a group of chemicals with a very common, a single commonality, which is a very strong carbon-fluorine bond, which is the third strongest chemical bond in nature. So it's really important to remember that not all PFAS are the same. We'll cover a lot of the EPA regulatory and guidance updates. States are taking their own actions, oftentimes more and more frequently than EPA, but for purposes of today's webinar, we're going to focus more at the federal level. We'll talk about PFAS in the environment. My colleague Jim will talk about PFAS in products, and a brief word about Chevron deference based on the recent Supreme Court cases. Bill will cover litigation updates and risk management strategies, and we'll conclude with some overall strategies and best practices. So I've been presenting on PFAS for years, and I used to say that we're just at the tip of the iceberg in PFAS issues. Well, now the iceberg is way out of the water, and it's going to continue to grow. It's really important to stay current on the changes. I spent the last, 24 hours making sure that each of my slides was as up to date as possible, because the changes do happen so rapidly. That said, there might have been changes in the last 20 minutes that I didn't cover in this presentation. So it's just really important to stay on top of the federal and state change, regulatory and litigation and statutory developments. One thing that we counsel our clients a lot about is whether you want to be proactive or reactive in making decisions about PFAS. And there isn't one right or wrong way of doing it. In each case, in each company, and each entity has its own PFAS risk profiles and decisions on how they want to address it. But you can decide to be proactive or reactive or somewhere in between. And we do often recommend that investigations be done under privilege. And one very important aspect of PFAS are how you handle PFAS as it comes up in public relations and communications. Do you have a communications protocol? How do you handle a new emergency that comes up if your company or entity, municipality, becomes the subject of an expose in a news article, for example? So PFAS are ubiquitous. The trademark is not a real trademark, but the point here is that the term ubiquitous is used all the time in PFAS discussions because PFAS are ubiquitous in the environment. It's found as far away as the Arctic Circle in places you wouldn't expect it, in Arctic ice. The Washington Legal Foundation, which is the center graphic here, has an interactive website where you can search for PFAS either used or disposed of or released into the environment. And it's almost all of the center and eastern portion of the United States and a growing part of the West. And PFAS are ubiquitous because they've been used a lot, but also because they are very stable. It's a complex mixture. It's a stable they are stable molecules, and they're mobile in water, which makes environmental remediation of PFAS especially difficult. PFAS are used and have been used, as Glenn said, since the 1940s or 50s, and throughout the 60s, 70s, and 80s, and into the 90s, most predominantly AFFF, which is the aqueous film-forming foam, a product used to fight fires that can't be fought with water, is a very significant source of PFAS in the environment. And then a wide variety of commercial and industrial products that we're very used to, like nonstick pans and stain-resistant treatments for our fabrics and waterproofing on our clothes and shoes. Food products as well, and then a wide variety of industrial, commercial, cosmetic products all use a variety of PFAS. And because of that ubiquitous nature of the use and existence in the environment, there are a lot of liabilities that have come to exist over the last many years, certainly for PFAS manufacturers, but also users of PFAS. Users of PFAS who intentionally used it, and PFAS users who didn't know that they were using it or didn't realize that they were using PFAS in their products. Municipalities, of course, have a tremendous and growing burden on treating water that they are treating and disposing or using for water supplies that contain low levels of PFAS. The parties that have stored, used, or disposed of AFFF, that includes firefighting departments and landfills and commercial and industrial operations, airports. Their AFFF has been used so much, and its use in actual fires and in training exercises has led to significant PFAS contamination at and around those locations. And it's not just where the PFAS was used, but because it's mobile in water, it may have migrated from property to property. Some of the current issues involved PFAS in drinking water and air deposition. And one of the newest environmental media or exposure pathways that we are seeing discussed more and more is vapor intrusion. We're used to vapor intrusion with volatile organic compounds, chlorinated VOCs such as TCE and PCE, but there are certain PFAS that are volatile, and there is not a whole lot of study, but a growing amount of study and focus on vapor intrusion for PFAS. So when we talk about PFAS as how it's being regulated and pursued by the federal government, the Biden administration, the Michael Reagan EPA are very much focused on PFAS. It's been part of the Biden plan since he ran for office. The EPA published a strategic roadmap that we're going to talk about in a few minutes that covers a whole of EPA approach to regulating PFAS in all of the different environmental statutes and regulations. And most recently, EPA listed addressing exposure to PFAS as one of its priority national enforcement and compliance initiatives in August of 2023, which is the first time the PFAS has been listed in this regard. The PFAS strategic roadmap that EPA published in 2021 has been updated and reported on since 2021. The primary aspects of the categories of how EPA is addressing PFAS are the 3 R's: research, restriction, and remediation. EPA recently published in just last month its 2nd annual progress report on the strategic roadmap. It covers all of the developments in 2023 and plans for 2024 for a wide variety of the aspects of the plan. The ones that are highlighted in the peach color are the ones that I'm going to focus on here today, but I recommend that you take a look at the progress report for a nice summary in about 15 pages of all that EPA has done and plans to do in the coming year. So the first really important regulatory rulemaking that EPA is pursuing relates to CERCLA, the Environmental Remediation Statute and implementing regulations that govern site remediation across the country. No PFAS, as of today, are listed as CERCLA hazardous substances, meaning that EPA, under its primary CERCLA jurisdiction, doesn't have authority to mandate cleanup under CERCLA. It's finding unique ways to ask for testing and remediation, but in order to fill that gap, EPA proposed a regulation in 2022 that is set to be finalized in the first quarter of 2024 to list 2 of the most widely used in the past and widely studied PFAS, which are PFOS and PFOA, as CERCLA hazardous substances. This is creating a lot of concern among the regulated community, not just private industry, but also municipalities who will potentially be subject to liability once the rule is finalized. And because of that, EPA is working on an enforcement discretion policy to try to alleviate some of those concerns, but we'll talk about how those concerns are not necessarily going to be alleviated by the forthcoming policy. But first, let's talk about PFAS and the potential impacts that the CERCLA hazardous substance designation might have. The first is that CERCLA is a joint and several liability statute, meaning even if you aren't necessarily the party that first was responsible for the release, if you're the owner of the site where the PFAS has come to exist, you could be liable. The regulation will also create reporting obligations under CERCLA. EPA is already listing PFAS in its 5-year reviews, which is leading to potential investigation and remediation, and it'll certainly be more the norm once the regulation is promulgated. It also raises the concern of reopening sites, either sites that are completely closed or delisted, or sites that are very mature in their remediation and have consent decrees or administrative orders on consent that have broad language such as imminent and substantial endangerment or otherwise provisions that say that EPA can pursue or ask the regulated potentially responsible party to take further action for contamination that EPA believes is necessary to either investigate or remediate. So what will the impact of this be? It's going to lead to a lot of finger pointing, and it's going to lead to a lot of fingerprinting. So fingerprinting, the concept of forensics or fingerprinting is becoming very common in the PFAS world because of the ubiquitous nature of PFAS. Parties are realizing that even if they are responsible for PFAS, for example, at a PFAS manufacturing plant, that doesn't mean that all PFAS either on the property or in the surrounding property is caused or was released by that manufacturing entity. And in fact, it's often the case, and I have experienced this in sites myself, where chemical fingerprinting, it's often referred to as a principal component analysis, or a PCA, finds different PFAS fingerprints even for the same PFAS. So for example, there might be PFOS surrounding a site where one entity is responsible, but there are different PFOS fingerprints surrounding the site. It's going to lead to arguments that one party is not responsible for all of the PFAS contamination and other parties should come to the table. And that'll lead to a lot of finger pointing. So a brief word on the enforcement discretion policy. The policy is not yet in effect. It's a guidance document that EPA rolled out last year, not even as a draft, but as a concept, and had listening sessions for entities to weigh in on. So EPA is more or less saying that they will focus their efforts on the parties whose actions resulted in the release of significant amounts of PFAS, and it might forego enforcement against community water utilities, publicly owned landfills, farmers who apply biosolids containing PFAS, and or state, tribal, or municipal airports that stored or used PFAS in AFFF. One of the problems is that this is not part of the law or regulation, that the PFAS hazardous substance regulation. It'll be guidance only, and municipalities are very concerned by the fact that it's merely a guidance document. Today's news has a story, for example, mayors renew fears over high costs of EPA PFAS drinking water limits, which we'll get to in a moment with the related drinking water regulation. But the idea is the same, and that is municipalities who are incidental or downstream treaters of PFAS might have liability. So we will see what happens with this enforcement discretion policy. EPA does not appear inclined to carve out liability for municipalities, nor does Congress, despite calls for some sort of exemptions, appear inclined to do the same at a statutory level. So as I mentioned, another regulation that EPA is in the final stages of promulgating, and it's expected to be final very soon, is the drinking water maximum contaminant level, or national drinking water, primary drinking water levels for 6 different PFAS, including PFOS and PFOA, which have extremely low proposed MCLs of 4 parts per trillion, but 4 additional PFAS that EPA is treating as a mixture because they are commonly found together. The note at the bottom of the slide is another recent article noting that in our state of Dayton, Ohio, expects to spend millions of dollars to reduce PFAS chemicals in the city and county drinking water supplies. You could replace Dayton with any county or city or local municipality across the country that will have a similar concern. In Dayton's case, the levels that they are detecting are also very low, 7 parts per trillion, but that would be above the 4 parts per trillion level that the regulation would call for PFOA. A note on 4 parts per trillion, it's EPA states, and I think laboratories will largely concur that 4 parts per trillion is the lowest level that most labs can detect. You can see how the EPA is responding to drinking water concerns, investing or planning to invest billions of dollars through the bipartisan infrastructure law in the forms of grants and other funding mechanisms to provide money to municipalities to add treatment for PFAS. But as the article that I just waved in front of the screen notes, many mayors across the country are concluding that this is not, the millions of dollars or the $10 billion is not nearly enough to fund all that's needed to treat PFAS in wastewater and in drinking water. Last year, EPA took enforcement action under the Clean Water Act for the first time against a party for a PFAS manufacturing site. This is a site in Parkersburg, West Virginia, that has received a lot of attention over the years, including a Hollywood movie. And this was the first, but not the last, of the drinking water enforcement actions that we're going to see, in part because the National Enforcement and Compliance Initiative that I mentioned a few minutes ago will be part of EPA's plans for the next several years. RCRA, the Resource Conservation and Recovery Act, is also another law and a regulation under which EPA is proposing adding PFAS, certain PFAS as hazardous constituents. This is just going to lead to more cleanups or risk of cleanups under the RCRA statute. I'll spend a moment on the TSCA, the Toxic Substance Control Act PFAS reporting rule, because it was passed in the fall of 2023 and is really a very broad reporting rule. It's a one-time reporting rule that EPA promulgated because it was required to under a statute. But this rule is requiring parties to look back to January 1st, 2011 to December 31st, 2022 to evaluate whether they either manufactured, as that term is defined in the TSCA PFAS rule, or imported an article from abroad containing a PFAS into the United States, and report on a wide variety of aspects. The type of PFAS, the amount, health exposure to workers who may have been exposed to those PFAS, and where those PFAS were disposed of. This is a very broad rule. The term PFAS is defined as a structural definition rather than a list of PFAS. So parties will have to evaluate that PFAS definition and determine whether their operations trigger the rule for reporting purposes. The deadline to report is, for most parties except for small businesses, is May 8th, 2025, but it's going to take all of 2024 and into 2025 for many parties to do this investigation. So I've been counseling clients starting with a simple question: do you have a plan? Do you have a plan as to how you are going to meet the diligence requirements under the rule? And how are you going to report or determine that you don't need to report under the rule? And the quote at the bottom is from EPA. The data that EPA will receive is a game changer in advancing the EPA's ability to understand and effectively protect people from PFAS. My takeaway from that quote is that EPA will garner a lot of information from the rule, but Others will too, and this includes citizens groups, plaintiffs' law firms, and others who are interested in understanding where PFAS is being used and introduced into the environment. So just a word about states. States are regulating PFAS themselves. Many states, over half of the states are taking substantial action to ban PFAS in products, to designate PFAS as hazardous substances under state law, to set drinking water limits, to require remediation or investigation limits for PFAS in the states. So I just commend you to understand where your operations are, where your products are going, because it's not just a matter of understanding the federal requirements. It's really a state-by-state analysis. And if the United States wasn't more difficult enough to understand all the rules and requirements, the EU is considering a total ban on PFAS in products. The definition of PFAS under the EU proposed ban would be at least one fluorinated carbon atom, which is a very broad definition of PFAS. That rule is in the rulemaking stage right now, and it might go into effect the ban on products may take effect in 2025, and there are other restrictions may begin in 26 or 27. So the EU and many countries around the world are focusing on PFAS as well. So in conclusion, know your business, know your entity, where are your PFAS risks. If you have not done a PFAS desktop study or you don't know anything about your PFAS potential liability, that might be something that you want to consider. Product reformulation is easier said than done, but many companies that we work with and I see across the country are finding ways, or at least investigating how to reformulate their products just to cut off the liability at this point. You can't necessarily do anything about past liability, but going forward, that's a possibility. If you have PFAS, for example, in storage containers or an AFFF, secure against releases or potentially get the AFFF out of circulation. A whole other topic would be PFAS in transactions, how we are seeing corporate and real estate deals be affected and addressing PFAS in those deals. The insurance community is addressing PFAS as best they can. And as I mentioned, one proactive versus reactive consideration is, do you remediate a site now, or do you wait until it has come to the attention of a third party and you have to deal with it at that stage? So I know that was covered a lot in 25 minutes, but I am going to turn it over to Jim to talk about PFAS in the FDA. And I look forward to hearing any questions you may have now or after the presentation. Thank you.
Thanks, Joel. So hi, my name is Jim Fraser. So you're looking at a picture right there of FDA headquarters in Silver Spring, Maryland. That was my home for about 5 years. I was an attorney in the office of the chief counsel at FDA. So I'm going to talk about how FDA is getting involved with PFAS. FDA likes to say that it regulates approximately 25 cents of every dollar spent by US consumers. Not sure precisely how accurate that is, but FDA does regulate a lot of the US economy: food, drugs, cosmetics, medical devices, radiation emitting devices, veterinary products, including veterinary drugs and animal feed, and then tobacco products. So a big swath of the economy is regulated by the FDA. In terms of PFAS, though, what we're seeing is FDA is going a lot slower than EPA. And the limited activity we've seen from FDA has been focused in really 3 different areas: cosmetics, food, and food contact substances. So if I can have the next slide, please. So this is a statement from the FDA website from February 2022. In fact, it's still there. I'm not sure why they haven't updated it. And I won't, read through all of it, but the gist of it is, FDA knows that there's a lot of media attention about PFAS, and they know that a lot of consumers will be thinking about PFAS and their different products. So in terms of cosmetics, the FDA let the public know, and there's a lot more on the website than this statement. But in February 2022, FDA, the gist of it is, look, we're doing research into this area to get a better understanding of, whether this is a problem, whether there should be concerns with the fact that we have PFAS in cosmetics, and we will keep the public updated as we move along. Next slide, please. However, at the end of 2022, when Congress passed the budget reconciliation bill, Congress included in that bill something called the Modernization of Cosmetics Regulation Act of 2022, or MOCRA. This was a big deal. FDA has traditionally had very little authority over cosmetics. For years, FDA had been lobbying Congress to give it more authority over cosmetics. So MOCRA gives FDA a lot more authority over cosmetics, and it's going to be phased in over time. And examples of things that are in the statute include FDA is required to promulgate regulations regarding manufacturing practices for cosmetics. Manufacturers of cosmetics are now going to be required to send FDA the lists of their ingredients for all of the cosmetics that they've got on the market. There's going to be labeling requirements, new labeling requirements. There's going to be requirements to report adverse events. So really a big deal. However, at the very tail end of MOCRA, this is literally, I think, the second to last provision in the statute. Congress basically told FDA to look into this PFAS issue, and 3 years from now, please publish your results on your website. So this was a classic example of FDA or the Congress sort of punting on an issue that they just figured out that let's just let FDA look into this, give them 3 years to look at it, and at that point we'll figure out what, if anything, Congress wants to do, or if the research that FDA does on cosmetics results in FDA wanting to do something. Next slide, please. So what could FDA do if in the terms of cosmetics, if it thinks that there is a problem? FDA can promulgate regulations that prohibit ingredients in cosmetics. And over the years, FDA has promulgated, it's a small number of regulations, and it's been a while since they have actually promulgated a regulation barring a particular ingredient in cosmetics. But if Congress isn't going to take particular action regarding cosmetics, FDA would have the authority to do that. But we thought, in putting together this presentation, this would probably be a good time to quickly delve into a hot topic in the law right now, and that's Chevron deference, because the Supreme Court a couple of weeks ago heard oral argument in a couple of cases on the issue of whether to overrule its 1984 Chevron opinion. And as many, if not most of you know, Chevron dealt with what kind of deference to give to an agency when the agency promulgates a regulation that interprets a statute. The Chevron two-step, as it's called, basically tells courts to look at the statute. If the statute doesn't clearly answer the question, if it's ambiguous on the specific question, then you move to step 2 and see if the federal agency's regulation that applies the statute is a reasonable interpretation of the statute. Does not have to be the best interpretation, so long as it is reasonable, and if it's reasonable, you should defer to the agency. That's what FDA or the Supreme Court is grappling right now, is whether if a court thinks there might be a better interpretation of the statute, should it just defer to the agency's interpretation? Seems like from the oral arguments that the Supreme Court's going to scale back that somewhat. always hard to predict what exactly is going to happen. But I think the effect of that, in terms at least of the FDA and maybe some other agencies, is they're going to have to be even more careful than they have been in the past in promulgating regulations, because they're going to have less deference when when they get challenged in court. I can tell you from personal experience, FDA already, when they're promulgating regulations, does its very best to try to make sure that it's protecting itself from court challenges, and really trying to create a record showing that not only its regulation is reasonable, but really is better than any other options that are out there. But this is one thing that everyone who works in regulated industries is going to have to keep their eye on. And then lastly you've got a mention of Skidmore deference. That's a Supreme Court case from 1944. Long story short, and that was talked about a lot in the oral arguments recently, that when even if you're not going to give Chevron deference to an agency's interpretation of a statute, courts really should take a close look at the agency's reasoning that it came up for its interpretation of the statute, and maybe not defer to it, but maybe give it a really hard look. And I can tell you from my own experience at FDA, I won a case where the issue was Chevron deference, and then the judge dropped a footnote at the very end and said, you know what, even if I wasn't applying Chevron deference to this case, I would still let the FDA win, or give the FDA rule for the FDA under Skidmore deference. The decision from this case should be out in June, but could have an effect going forward on challenges to regulations, not just on PFAS, but in all areas. Next slide, please. So what has FDA been doing on PFAS? I can tell you FDA does testing of the food supply, literally buys products at grocery stores from a broad range of products that are commonly used among the average American consumer, looking to see if there are problems with any products that they find. And there's been a couple of examples where FDA has found, I think it was in canned clams that came from China, where FDA was concerned that the level of PFAS was too high. And FDA asked the companies to voluntarily recall those products. But other than that, FDA has not found in the general food supply levels of PFAS that have been problematic. But FDA makes sure to let people know that, sampling has been limited so far. They're going to keep doing the sampling, trying to broaden it out. And if there are problems, take appropriate action. I can tell you, if you're in the food industry, and this generally goes for FDA in all areas, FDA has enforcement mechanisms in place. They can take legal action against companies for selling products that don't meet FDA standards. But in most cases, FDA tries to work things out with companies to get companies to voluntarily comply or come into compliance with the law. Because at the end of the day, that's what FDA is most interested in. FDA is not really all that interested in issuing fines. I don't even think FDA gets to keep that money. They're just most interested in trying to get people to come into compliance. I'd get the next slide, please. And then the other area that FDA has been a little bit active on is something called food contact substances. And those are substances that come into contact with food but are not intended to have a technical effect on the food. This includes food packaging, processing equipment, cookware, pots and pans, things like that. Since 2020, FDA has worked with manufacturers to phase out certain short-chain PFAS substances. And FDA is currently looking into whether PFAS can form on its own in certain other types of food containers. And FDA has asked manufacturers to submit information about those containers. FDA asked for that information. I think the period to submit that information was ended in October of 2023, and have not heard anything from FDA since then. But my guess is if they're finding problems in other types of food packaging, again, the way that FDA is going to tackle that is to try to work with manufacturers to come up with a solution rather than, bringing enforcement actions and things like that, because it's just a lot simpler for FDA to go through that route. And I think that's what I've got on FDA.
And Jim, I know it's beyond the scope of this presentation, but many states are passing their own state laws prohibiting PFAS, intentionally added PFAS in food packaging and utensils, plates, etc. So again, just an admonition to check your state as to whether your state has a law that's already in effect, which several states are, or has laws that are passed that are not yet in effect for PFAS in food packaging.
Yep. Thanks, Joel. And I can tell you, not to get into too much into preemption, but sometimes people, without a full understanding of preemption, will say, well, if the FDA hasn't taken action here, can the state really do so? And I can tell you in terms of food packaging and for PFAS, you're not going to have a preemption argument. I mean, FDA, just the fact that FDA hasn't gotten into that area yet doesn't prohibit states from doing so.
Good. Well, thanks, Jim. So I'm Bill Hubbard. I'm going to spend the rest of the time before questions talking about litigation. And as you can tell from Jim and Joel's presentations, the litigation is centered on exposure to PFAS, either through ingestion, through drinking water, or through food contact, or dermal exposure through exposure to coatings, or exposure to cosmetics and things of that nature. And so there's two groups of cases of litigation. One, your typical contamination cases, and then your content or your disclosure cases. So next slide, please. Originally the focus was on the contamination cases, and we got a list of the common causes of action. We thought we had kind of seen the number of cases filed plateauing in 2021 or 2022. Next slide, please. But you can see here's it's what we thought might plateau in 2022. It continued to increase in 2023, and it's continuing to increase this year with more and more cases filed all the time. So next slide. Just a quick history of how this all started. If you've seen Dark Waters, you know the story, but originally it started with a farmer whose cows were getting sick. They traced it back to a landfill that had PFOA coming out of it. That was a byproduct to make Teflon. That family settled, but then the documents and science that was developed in that case was used for a class action here in Ohio for people who were exposed to groundwater. And part of that class action settlement was the creation of a science panel that would look at the issues of general causation. For a typical toxic tort case, a plaintiff has to prove general causation and specific causation. So the general causation is generally, can this product or this chemical cause this type of disease? And then specifically, you need to prove that, yes, this particular plaintiff was exposed to a sufficient amount of this chemical to cause his or her disease. And so the class action settlement was to appoint a panel, the C8 panel, to look at that general causation issue. And they identified 6 diseases, from cancers to kidney disease to hypertension to some reproductive issues, as meeting general causation. And then from that, there were individual cases were tried and ultimately settled. And it's this kind of these settlement amounts that kind of spurred the interest in different PFAS chemicals. Next slide. Of course, there's similar, anytime this kind of thing happens, there's shareholder class actions. again, in a whole nother presentation for those. But you've got mostly the next slide, mostly the cases early on were focused on manufacturers of the PFAS themselves, and mostly the costs to treat groundwater. The way that the groundwater is treated, these at a cost of millions of dollars for a municipality, what they'll do is they'll install these enormous tanks containing granulated activated carbon, through which the water is passed to pull out the PFAS from it. It's millions of dollars to install those tanks, and then that carbon needs to be changed out yearly, if not more frequently, depending on the volume that's going through it. So that's the cost that most of these municipalities were suing the manufacturers of PFAS to be compensated for. Most recently, Connecticut, the state of Connecticut was the most recent state to sue the manufacturer just last week. But most of those cases, at least with respect to the AFFF cases, which pertain to the firefighting foam, those were consolidated in an MDL in South Carolina, which was recently settled. Next slide, please. And so the terms of that settlement, 3M had over a 13-year period. They're going to provide $2.3 billion towards the settlement, which provides a process by which the municipalities can opt into the settlement and test for and treat PFAS contamination. Next slide. There's currently a public water system settlement claim process underway that there's different phases to it, and it's going to last for the next 4 or 5 years, the settlement claims process. Next slide. There has been some success, though, on behalf of the defendants, most recently in the Hardwick case, which pertained to an attempt here in Ohio to certify a class of every person who has 0.05 parts per trillion or more of PFOA or PFAS in their blood. That is almost everybody. The court here in Ohio, the federal court, it certified a statewide class of Ohioans who had that amount of PFOA or PFAS in their blood. Just recently, however, the Sixth Circuit reversed, finding that the particular plaintiff, who was a firefighter, lacked standing because there's no allegations of a specific pathway that he could prove any particular defendant's PFAS there is a clear pathway from that manufacturer of the PFAS into the PFAS detected in his blood. A great quote from this case that will be used in other PFAS cases and other litigation, toxic-tort litigation in general, is seldom is so ambitious a case filed on so slight a basis. So it's kind of getting back to the root of, you've got to prove that the particular defendant was actually exposed to the defendant's product. Next page.
Bill, if I remember correctly, that quote was actually the Sixth Circuit's opening line of its opinion.
Yep. Yes. So, and that will be one of those quotes you see repeatedly. So after you have the manufacturers of PFAS, then you look at the secondary manufacturers, meaning the ones who are using PFAS in their products. Obviously, as Joel touched on, the PFAS is used for waterproofing. So any product you think of, whether it's Gore-Tex or boots or shoes or carpeting, all of those manufacturers have been the focus of various types of this originally the contamination type lawsuits. Next, please. And then to touch on what Jim was mentioning, there's every time a study comes out finding PFAS in a certain type of products, as you can imagine, litigation follows. And so in 2018, a risk assessment was done, and PFAS was found in cosmetics, and of course that then started the class action. A lot of which, for these types of cases, we're starting to transition from the contamination cases to the content cases. So where it's the false advertising cases alleging that that you either said it was PFAS free, or you said it was safe, or something of that nature, or it's all natural, and here it has PFAS in it, so it was false advertising. The plaintiffs claim they either would not have bought it at all, or they would have bought it for less. There's a whole body of law on those false advertising cases, because they follow along with a lot of the cosmetic cases for whatever, name your product, whether it's BPA or phthalates or other products that formaldehyde, things like that. It's a typical playbook that the plaintiffs have, but they've just put PFAS into that playbook. There has been one success recently, last September, in the Southern District of New York. A manufacturer of mascara was a class action was filed against the manufacturer, alleging that PFAS was contained in their mascara, based upon a study. There's a professor at Notre Dame who does a lot of these studies, and he generally studied a lot of cosmetics and found PFAS in there, in those cosmetics, and that's what the plaintiffs relied upon as a basis of their class action. The Southern District dismissed that class action, finding that, similar to what we talked about before, there was no actual allegations that the particular manufacturer's mascara had PFAS in it. Yes, there is a study done that found found PFAS in cosmetics, and a couple of particular cosmetics, but this manufacturer's mascara was not tested, and there is no basis for those allegations. So the manufacturers and defendants are starting to have some success in pushing back on these cases. Next slide, please. Food packaging, again, similar to what Jim touched on. Again, following the same timeline, where there's a study, a report done. This time it was Consumer Reports, found PFAS in packaging, and then that led to a lot of subsequent litigation. This kind of reminds me to touch on something that's specific as to testing. So as Joel mentioned, there is difficulty in testing for PFAS, and a simpler test is to test for fluorine, and then you assume if there's fluorine in it, that a portion of that fluorine will be associated with PFAS. Sometimes you're not actually testing for PFAS. And so that's one of the important things for these studies, is to look to see, especially if you're the target of litigation, look to see what the plaintiffs are relying on. Are they relying on actual test results that show that the product actually, the specific product actually contained PFAS, and specifically what type of PFAS? Because, as we said, there's thousands of types of PFAS, only a small fraction of which have been tested for. Next slide, please.
And Bill, our toxicologist friends have warned us that it's very suspect to be using total organic fluorine.
Yep, absolutely. Which leads to our next topic, which is the PFAS free. So and this is where we see a lot of clients coming to us for counseling, is there's a lot of consumer demand for PFAS free products. This is just an example that's been in the news. Again, because kids could be exposed to it. So obviously an audience that people are concerned about, but about the concerns about PFAS in artificial turf. There are certain cities and states that have banned PFAS. A lot of times school districts will require, when they're building a field, they will specify PFAS-free turf needs to be used. And so manufacturers of turf will try to supply PFAS-free products. There's a lot of issues with that because right now there's no specific recognized standard for what is PFAS-free. And there's a lot of the product itself, the manufacturer might not intentionally add PFAS to it, but some of the raw materials may have PFAS in it. And so you really have to assess the PFAS content of your raw materials and try to push some of that responsibility downstream, or I guess, or upstream to your suppliers to ensure that they are supplying you and can give you representations about the PFAS content. We recommend it's better to reference a particular standard, some which is recognized by the EPA. So you can say that it was tested to the ASTM D7968 standard. That's a particular group of PFAS chemicals that are tested as to a particular level. And so you can reference that standard as opposed to referencing that as PFAS free. Sometimes though, clients come to us and they're concerned because their current product might be PFAS free, but they know that their prior products are not. And so they are trying to figure out, and that's where we often get PR folks involved to help out. They are concerned about if they say their current product is PFAS free, or that their current product meets the ASTM D7968 standard, whatever it is. What then does that, you're kind of implying that your earlier product did not. And so does that expose you to some potential liability? Again, the good thing is a lot of the statutory language in some of the states where they're outlawing things, it's that PFAS was not intentionally added in the manufacturing process. And so a lot of times you can rely on that type of language in representations. Next. The other issue, again, with representations is the FTC green guides. These are the guides that the FTC publishes as to environmental claims, whether it's biodegradability or recyclability. There's a whole guidelines as to what companies should say about the environmental marketing of their products and services. The last time it was updated was in 2012. Obviously, PFAS was not as big of an issue then as it is now. They're currently evaluating updates to the green guides, and I suspect there will be some more product content and more PFAS specific guidelines as to what manufacturers should say about their products or services with respect to environmental friendly or natural or things like that, so that you do not get accused of false advertising or false marketing. Our biggest comment for and advice for our manufacturing clients and others is don't go it alone. Next slide. There's a lot of trade associations out there who, if an industry is being targeted, whether it's the cosmetics or turf or food or what have you, there's a lot of industry associations out there who can help message and get out there the message of PFAS in the product and how it's either not in the product or what the industry is doing to get rid of it or things of that nature. Again, it's our recommendation always is to before there's a newspaper article or something online about your product, it's best to know what's in your product and whether PFAS is or is not in it, so that you can make the decision of, okay, can you get it out? Because whether or not the science is there as to causation and disease endpoints, it definitely is there from a consumer preference. And so you're going to probably want to get the PFAS out of your product. And that obviously takes a long time to do. And so we always recommend that you start that process, at least evaluating it, and then also kind of have a game plan where if articles come out, or if you are if you're sued, hopefully you kind of have a background and a game plan in place already to address those issues. So that's the litigation front for now. So Joel, I'll hand it back over to you about your little iceberg analogy here.
All right, thanks. So we're at 2 o'clock. This is the conclusion of our prepared slides. So of course, the iceberg keeps getting bigger. One thing I'll note in the litigation world, which would be a confluence of Bill's world and mine, is litigation over the regulations that are being promulgated. Once the rules become final, will industry groups sue EPA or other regulatory bodies for the regulations being arbitrary and capricious or otherwise not legal? And what will that do for the implementation of those rules that have taken so many years to put through the regulatory process? So, it's fast-paced change. Keep up to date. Thompson Hine continues to follow a large number of these categories, and will continue to work with the WLF on presentations and articles on PFAS topics. But we really appreciate your time today, and thanks for listening.
There are some questions. We hit the 2 o'clock hour, so you're free to go. But I think Glenn, the Zoom or the Zoom stays open for a little while, right?
It does, yes. So I'd definitely like to
Okay.
get to these questions if we can relatively
Sure.
rapidly.
So Joel, and I think some of these are probably geared towards you, so I'll read them out to you. What PFAS related legislation has the best chance of reaching POTUS's desk in 2024, or at least advancing to a floor vote? So the question is, what legislation, is there any legislation kind of currently percolating up that you see reaching the president's desk, or at least kind of advancing through Congress?
Yeah, it's a good question. I know that there are several largely Republican proposed laws that would in part take away some of the things that EPA is trying to do. I haven't followed them in the last several weeks to see where they are, but I know several of them have been moving through the legislative process. So I can't answer that specifically as to which ones are most likely to get there. But I do know that there are several laws that will continue. I mean, the question in a divided Congress is, can any law get the required number of votes, especially in the Senate, to make it to the president's desk?
Right. And then the next kind of part of that question was, which bills should be on a water quality advocate's wish list, or would be most impactful in remediation/reduction of PFAS exposure? I mean, personally, I think that's going to come from a lot of the class action settlement, and also although Joel is completely right, there's probably not enough money there in the fund from the government, but it is trying to put these the granulated activated carbon tanks on municipal water supplies and try to scrub the PFAS out of the drinking water. And so as EPA is lowering the water quality standards, I don't really think it can lower it much more. I think it's going to probably have to take it in steps, just because it's so expensive to get it out of the drinking water, that I think it's probably going to work its way through these municipalities starting to install these tanks and things like that. That's probably how they're going to get most of the drinking water exposure under control. Joel, what are any thoughts?
Well, on a related point there, keep in mind that the national primary drinking water standards that are being proposed and should be final this quarter are for 6 PFAS only. And because there are thousands of PFAS that could be regulated, EPA continues to collect data on other currently unregulated PFAS that are, of course, in the water supply. So as those studies and, for example, the uncontaminated drinking water rules are being implemented, you're going to see EPA proposing additional drinking water standards, which have both drinking water and remediation impacts.
Yeah, and that kind of touches on the second question which was, what's your prediction on how states like Maine or Minnesota or the EPA will prioritize enforcement against product manufacturers responding to TSCA's PFAS rule or the upcoming state reporting requirements? And then will regulators give a pass to organizations that made a good faith effort and were forthright and go after organizations that failed to report? There's not enough time or resources to go after all organizations. So how will these agencies prioritize their enforcement efforts? So
yeah, several questions, and they're all very good ones. I'll focus first on the TSCA PFAS reporting rule. It implicates, as I mentioned, anyone who manufactured, as that term is defined, a PFAS, which there could be tens of thousands of them, or imported an article into the U.S. with one of those PFAS. And so the question, as the audience member asked, is how does EPA enforce? It's almost like proving the negative. How do you know if somebody didn't report when they should have reported? A lot of the clients that I've been speaking to are asking that question, and it's not that they're trying to skirt their obligations. It's simply, what if we do our diligence and we meet the standard under the TSCA rule, and we just don't have records, especially going back to 2011 when, maybe we didn't even know what PFAS were. How are we going to find records that show that we were importing or manufacturing a PFAS, and even more so, where it was disposed of, or risks or exposures to workers? I think the answer is, in part, is the audience member asked, is EPA going to give a pass to organizations that made a good faith effort? I'm not sure that they'll give a pass, but there are only so many resources and so much time and money that EPA has. The best that I can tell you and anyone to do is do your best,
right.
organize have a plan. I'm preparing action plans for clients as to how they're going to implement the TSCA rule, and keep records of it. Show that you reached out to foreign suppliers. You asked them, did they supply an article that contained a PFAS? If the answer is no, or they didn't respond, you can't manufacture records that didn't exist, and that's the best that you can do.
Right. And I think also the EPA is likely to focus on where the potential exposure either is the greatest from a volume perspective, or the exposure is greatest, meaning from the ingestion or dermal exposure. Like you look at like how they treated lead exposure, right? They're focusing on children's toys, and the regulators are focusing on things like that, as opposed to other parts that or other things that there might be exposure. So I think they're probably going to focus on, like they already are now, on cosmetics, on food coatings, on things that especially children are potentially exposed to at either a high volume or very closely exposed to. So I think they're probably going to focus on those types of industries first. Or sometimes there's a product that gets a lot of news and it has legs just because of the product is a kind of unique product, or there's a lot of newspaper articles. And so the EPA will focus on that product just because there's a lot of news about it. And the actual exposure pathway might not be that great, but it just those news articles get legs. So I think they're probably going to focus on the industries, like I said, whether there's a more clear pathway to exposure than some of the other industries with respect to product content.
And EPA and many state regulatory agencies know very well what products, and it's a very large list of products or categories of products, but they know where to be looking. And so if I don't know this from any firsthand knowledge, but I suspect that EPA will be focusing in large part on the manufacturers of PFAS and the primary users of PFAS in products, and in looking for the TSCA reports to see, did the manufacturers, did the producers that EPA would expect to see reports from report? And if the answer is no, that's a low-hanging fruit. And if the answer is yes, but then they go into the report and it doesn't seem sufficient. For example, the TSCA rule says if you don't, if you know you have PFAS to report, but you don't have specifics, you can report under the common TSCA phrase of not known or reasonably ascertainable. Well, if you overuse that not known or reasonably ascertainable, perhaps EPA would say, you shouldn't be falling back on that. You really should know more. Whether they actually seek enforcement or utilize information requests to try to garner more information, I don't know, but I think the question is very spot on. And how will EPA and states who are passing their own laws be able to get their arms around what is such a big problem, or potential problem?
I want to thank the audience members who asked questions and all of you who participated in the program today by tuning in. Again, if you'd like to see the recording of this, it'll be available on WLF's website and on our YouTube page later this afternoon. I want to thank all of our panelists for their excellent preparation and for covering so much ground in just an hour. We definitely appreciate your contributing your time and your expertise to WLF as we try to put this information out there. Everybody have a nice rest of the day.
Great.